Good morning, everyone. I'd like to call to order the Judiciary Committee meeting for whatever day we're on, March 8th. We have a handful of bills on our agenda and a relatively short speaking order, so let's try to keep this to under 12 hours today. First up will be Natasha Pierre.
Good morning, everyone. As you know, my name is Natasha Pierre. I'm the state victim advocate. I want to thank Senator Winfield, Representative Sonnstrom, and members of the committee for raising this bill. We have requested it, and it has been proposed in the past. The bill that we're in support of is House Bill 6637, and that concerns crime victims' participatory rights in a violation of probation or conditional discharge hearing. Crime victims have a state constitutional right to attend the trial and all other court proceedings the accused has the right to attend, and to restitution, which shall be enforceable in the same manner as any other cause of action or as otherwise provided by law. The violation of probation hearings are technically an extension of the sentencing, yet victims do not always have participatory rights at said hearings. If the violation, which I'll call a VOP, is based on the commission of a new crime, such as violating a standing protective order, the victim's participatory rights attaches to the new criminal case. If the VOP does not involve a new criminal matter, e.g. a violation of payment for non-payment of restitution, the violation is addressed as a civil matter and the victim has no statutory right to participate. Crime victims has direct interest in the outcome of the violation of probation hearings, particularly in cases where it impacts their case, either a restraining order or restitution. And in order to protect those rights, they need to have the equivalent standing as they do in other public hearings that defendants can attend. And this bill will do that. We also, this language, the particular language that came actually did not come, this new version of the language came actually from the prosecutors, or it came from the legislative department writing this after they had talked to prosecutors and public defenders who have opposed it in the past. So they thought this language would work better. It did not violate, it still does what we needed to do, and so we agreed to it.
Thank you. Questions or comments from the committee? Representative Callahan.
Thank you, Mr. Chairman. Man, thanks for taking the time to testify today. Having come from this background, I know the department does attempt to get victims notified, and we of course want to make victims whole that are owed restitution. But when it comes to a situation when there's not the ability to pay, whether the victim is there or not, I'm wondering and thinking with you out loud how we think this could help. Do you have any comment on that?
Regardless, they get to say to the judge, they owe me money, make them pay me. Whether or not they get the money is not the purpose of them having a say in it.
That's well said, ma'am, and I appreciate you coming in to say that. I think it does make a difference when
bill collectors just don't go away because we can't pay in real life.
I certainly agree with you. So thank you for making your voice heard today. Thank you, Mr. Chairman.
Thank you.
Attorney Pierre, have you had a chance to review the testimony from the judicial branch on this bill?
I did not from this year. Did they submit different language this year?
They did. They have some concerns as to the definition of hearing and timing requirements. So I would encourage you to take a look at that. And
well, I'm not sure how confusing hearing is and timing. They get to make a statement at some time during the process.
Understood, but ultimately the agency charged with, or the branch, I should say, and charged with administering this policy, we need to make sure is on board. So if you could connect with the branch and get back to us, we'd appreciate it.
Will do. Thought we had.
Representative Fishbein.
Thank you, Mr. Chairman. Good morning, ma'am. There's another aspect of this that it appears the language is very widely written. And I think the original concern was that if there's a violation regarding the actual victim of the original crime, that there would be notice. However, if the violation is, let's say that the judge releases the individual and says, don't smoke marijuana, something like that.
Mhm.
And they get caught doing that, has nothing to do with the original victim. Would you be comfortable with us perhaps carving those out?
Absolutely not. Because now we'll start with this charge as a carve out and then there'll be more. The judge just decides whether or not the victim's testimony will hold weight. Nothing changes in this process.
Okay, so in that situation, other than establishing or reiterating what originally put the person under the purview of our judicial system, I just question what that individual, if it's a violation of probation, let's say, that has nothing to do with the original victim, what that victim could offer to the proceeding.
Well, in that case, one, the victim can decide not to come because it's not related to them. So that's a done deal, still their choice. Second, even though that may not be what's on record as what's violating, he may have been raging drunk or raging high when he tried to kill the person. So everything does not get to the record as to how this person reacts towards the individual when they are influenced. So I'm not saying that it's definitely there, but it's not 100% always not something the victim would have a say in. So if the victim chooses not to show up, then they've decided to give up their right to say something. If the victim chooses to come and say something totally irrelevant to the issue at hand, the judges takes that with the grain of salt and does what they normally do and decide how they're going to move forward.
Well, thank you, and thank you for appearing remotely here today.
Further questions or comments of this witness on Zoom? Any questions? Nope. Thank you for being with us.
Thank you.
Bridget Costner.
Good morning, distinguished members of the Judiciary Committee. My name is Bridget Kessner, and I'm the Policy Manager with the Connecticut Alliance to End Sexual Violence. I'm here to speak in support of HB 6637. We also want to express our support of SB 881. HB 6637 fills a need that we regularly face in our profession. As a former post-conviction victim advocate, this legislation would have been deeply helpful to numerous victims that I served. I'll use my remaining time to share those experiences, but encourage you to review my written testimony for more information. Victims would often have flare-ups of PTSD, nightmares, inability to go to school or work, and even physical illness upon the discovery that the person who caused them harm was rearrested for a violation of probation or eligible for conditional discharge. It brought the case to the forefront of their mind again and made them unsure if they were safe. They were often worried for the person who harmed them, or they also worried that the person who harmed them may harm others. They had no way to communicate this re-traumatization and interruption to their lives in court, but they should. I also worked with numerous victims who were directly impacted by the behavior that caused a violation of probation charge. For instance, lack of restitution paid to the victim. Victims described a lack of restitution as a quote unquote slap in the face. They described to me the financial toll of paying these bills themselves and even a loss of treatment when they could not pay. They felt like this was another way the person who harmed them was controlling and hurting them still. Almost all of these victims asked if they could address a judge about how harmful this was to their well-being. I had to be the one to tell them that they did not have that right. Additionally, I had cases where those who had done harm were contacting or harassing the victim, despite the conditions prohibiting such actions. They were subsequently charged with a violation of probation. However, despite the condition being directly related to victim contact, the victim had no right to share the harm that this caused or give input for sentencing. HB 6637 can give them that right, and so we urge you to support this bill. Thank you very much for your time, and I'm open to any questions.
Questions or comments? Senator Kissel.
Thank you very much, Chairman Stafford. Good morning and welcome. Thank you for testifying in person.
Thanks.
So would you say as a general proposition that when a victim is notified, it's advantageous that they be able to participate in any subsequent proceeding, especially if they've been damaged in some way, but also that those proceedings also re-traumatize them to some extent because they're dealing with the perpetrator of the crime.
I can definitely appreciate both the impact that that notification can have, as well as the choice to participate or not. When a survivor experiences sexual violence, we recognize that their agency is taken away. And so as advocates, what we seek to do is give them agency wherever we can. In this particular situation, victims often find out from their peers, knowing that the person who harmed them is most likely in their community, based on what we understand about offending dynamics. And when they find out from other people that this person has been rearrested, they're incarcerated again, they had a violation of probation, if they're, don't receive notification, which, they should be receiving that notification. But should they find out from their peers or formally, they're often re-traumatized, and at least the ability to participate in some hearing can give them the right to decide whether or not they want to be exposed to that. So somebody may find it empowering to be able to express to a judge the way that they were impacted. Another person may find that to be re-traumatizing or harmful, but they're given a choice. If they know that that could be something that's harmful to them, they can decide to do what's best for them and step away and find empowerment in stepping away, or finding empowerment by stepping up and sharing their impact. But either way, the agency is what we find to be empowering.
And, you're using a word, and I'm hearing it more and more. And I was actually once upon a time trained to be an English teacher and a social studies teacher. And it's called, you're using agency. Their agency is taken away. You want to give them their agency back. And, typically I deal with terms like agency, like a department. How is that word used by you? And what exactly are you conveying? But when you say someone is engaged, their agency was taken away, what does that exactly mean?
Yeah, thank you very much for that question, because it is a term we utilize a lot in the victim advocacy field. So when I talk about agency, I'm really talking about choice. So victims, when they experience sexual violence, the autonomy and choice that they have over their body was taken away by the person that chose to harm them. And then later on, as they move through the process, when they're deciding whether or not they want to report the offense, when they're deciding what they want to say at a sentencing hearing, we little by little are giving survivors the opportunity, or they're taking the opportunity to get some choice back in their lives. And so we see agency as an important part in reclaiming someone's life after something so significant and traumatic as the removal of their body autonomy had occurred.
I really appreciate that. And first of all, I want to thank you for your work too. It's got to be really hard, but really important to the victims of these crimes. And now I understand much better, because if it's sort of like another term for choice, as much as the future proceedings and notifications may have a propensity to re-traumatize and cause problems, again, in utilizing that term agency, it at least affords them a choice. Do I want to participate, not participate? Do I want to get this off my chest? Do I want to tell them that I'm still reliving the trauma? And so those proceedings, while problematic, might be helpful in the long run. So I really appreciate that. And again, I really appreciate you coming and testifying here in person. Thank you, Mr. Chair.
Representative Callahan?
Thank you, Mr. Chair. Bridget, thanks for coming in person today. And I will say I witnessed firsthand the work you've done for victims over the years. So I appreciate that. In my contact with the judicial branch, Bridget, when a violation of probation warrant is entered into the system, a letter goes out to the victims, and I'm trying to understand where the gap is here. And individual officers would also notify the victims, but I think it's just when it comes down, there's a notification, but the hearing date is not notified. I think that's what we're getting at.
Yes, and it's great to see you, Representative Callahan, and I appreciate the work you've done as well. But yes, so while the victim will be notified often by a victim advocate and by the judicial branch about a violation of probation, they would not have information about, about those hearings specifically, and they wouldn't have the opportunity to weigh in.
Okay, that's why I was just clarifying, because I'm reading through emails from the judicial branch, and there is some notification going on, but it appears that is the entirety of the gap, which is the need for this bill. So again, thanks for your advocacy and thanks for coming in today.
Thank you.
Chairman.
Further questions or comments? If not, thanks for being with us.
Thank you very much.
Ann Mahoney.
Good morning, Representative Stafford, Senator Winfield, Representative Fishbein, Senator Kissel, and other distinguished members of the Judiciary Committee. My name is Ann Mahoney. I am the Wyndham State's Attorney. I am here today on behalf of the Division of Criminal Justice to testify regarding when we fully support the intent of Raise Bill 1182 and Act clarifying meanings of sexual intercourse and sexual contact. I believe you have my written testimony, so I would just like to highlight a few matters. One is that this proposed legislation arises in response to two decisions of the Connecticut Supreme Court issued last December with regard to a new interpretation of sexual assault. The purpose of this legislation is to respond to the court's invitation to clarify the intent of the legislature with regard to the crime of sexual assault. The proposed legislation will protect and support victims of chronic sexual abuse. And by making this legislation retroactive and expressing that intent in the legislation itself, it will avoid confusion and disparate treatment. I would be happy to answer any questions with regard to this if members have some. Thank you very much for your time.
Questions or comments from the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good morning, State's Attorney Mahoney. I'm just trying to drill down on what we're doing here. And I guess one of my concerns initially is if this law passed, which appears to affect a perceived loophole, it would be applicable to individuals that are currently being prosecuted for these crimes. Do you read that the same?
Yes, Your Honor. Yes, sir. Yes, Senator. Representative.
I think, and just trying to balance the equities here, I would, if it's already been established that application of the current language ends up with a certain result, I would think that it would be prospective as opposed to retrospective. But moving forward from there, can you just explain the actual, what the Supreme Court said and what the problem is here?
Sure. So this is a new interpretation, and there was a dissenting and a concurring opinion on these two cases. And the new interpretation is that the sexual intercourse refers to a single act and not a course of conduct. And in the footnote dropped by the court, it indicated that in other states, it allows for both. So the practical effect of the decision, which has changed the approach of prosecutors now, is that there was a pending case in, I believe, the Fairfield JD. And originally the prosecutor had filed 2 counts of sexual assault in the first degree and 2 counts of risk of injury to a minor. He had 2 different victims who were at 2 different locations. After these cases came out, he had to refile the substitute with the new information, and it ended up being 15 counts. In order to address this. So there are other states, I believe in the footnote, it refers to California and New York, who provide for the interpretation that this proposed legislation has. And because of the good work of this legislature in extending the statute of limitations over the years, it allows for victims to come forward when they're ready to speak about what happened to them. And when it's chronic abuse, it's very difficult for them to separate out individual instances, which according to the new interpretation, they would have to do. With this legislation, it would protect those victims from having to do that. And it would also, when it's applied retroactively to pending cases, existing convictions, it allows for more fairness so that you would avoid a situation of where a victim, if you make it prospective, then a victim whose case is pending now and ends up with a conviction, or in that particular case, they would be in a worse position than a victim who hadn't come forward until after the legislation came in place. So in order to avoid sort of a chaotic situation where there's disparate treatment, the best way to avoid that is to make it retroactive and to apply to all the cases that have been there. And then everyone will be on the same footing. All victims will enjoy the same treatment from the courts.
So I'm just trying to figure out the problem. is there a harm in having to charge multiple counts? I mean, if you can prove 5 of 15,
Mhm.
then wouldn't you rather have that than charge once and be a collective?
No, not necessarily. I mean, if there are, and this would be, leave it to an individual prosecutor's discretion. So there might be instances where you have very specific information about a singular event, and you can put the time frame on that or put something else that narrows it. But otherwise, you're making people have to go through many more, and by having more counts, there's greater exposure to the accused person, because once you've been convicted of, say, 13 out of 15 counts, you're at a much higher exposure in terms of punishment than you would be out of 1 or 2. I don't know if that fully answers your question.
No, and I'm sort of seeing it the other way. Certainly, if somebody perpetrates this crime, 13 times and they can be convicted of it, the penalties would be escalated. Whereas if, as a result of this, you need only, that 13 bad incidents get collectively shoved into one, then it's a lower penalty. That's the way I'm looking at it.
With all due respect, it actually works better for a victim who's been a victim of chronic abuse, who might not be able to give a very specific detail and separate out each of the incidents. And then we have child victims who do not articulate as well as adult victims. We have adult victims who've been victims of chronic abuse who are unable to say on this particular day at this particular time. And we also have victims of human trafficking. So where prosecutors can exercise their discretion, where we have victims who can articulate those separate instances well, we would probably charge them separately. But where we don't have that, we would like to have the opportunity to charge it as a course of conduct. And we believe that the court will be able to provide the punishment that's appropriate.
No, I understand where you're coming from. I'm just looking once again at the balance between the victim and the accused. And, traditionally, if the victim says on April 4th in a back alleyway or a bedroom somewhere located in New Haven, this bad act happened, the accused would have the ability to say, well, I was in Vermont that day, right? It's a defense. So I guess the concern is if can't prove beyond a reasonable doubt, but shifting to a pattern of conduct. Well, that's where my thoughts are. So
let me try to respond to that a little bit, which is that I've been practicing in Connecticut and doing these kind of cases, child abuse cases, for about 30 years. And rarely, if ever, can I remember an alibi defense as being a defense in a case. When we can actually pinpoint a specific instance, we will do that. And if there is an alibi defense, then that will be appropriately dealt with. But what we're talking here is trying to address the chronic abuse situations, because in the 2 cases where they provided this new interpretation, the sexual assault charges fell away for that victim. We don't want to have that happen if we don't have to have that happen. Generally, the defense in child sex abuse cases is nothing ever happened, or perhaps this child was abused, but not by this particular accused person. So if we can frame the information, and we would be responding most likely to a bill of particulars from the defense, we will frame that. But in instances where we had chronic abuse, where a child says she's been abused every day for months or years, rather than filing thousands of counts, it's much better for us to be able to have a course of conduct count.
No, I understand. And I look at the system, though, a trial can be just as harmful emotionally to the accused, to the victim as the accused. And certainly closure is part of that process. And if at the end of the day, that process is not as concrete as we can make it, people are let out, after a conviction. And, I don't know where I am. I am going to read those 2 Supreme Court cases though, and put that into my analysis. But I thank you for the exchange, and I was looking forward to seeing you here today and talking about this bill. So thank you. Thank you, Mr. Chair.
And if we can answer anything else offline, I'd be happy to do that for you.
Senator Harding.
Thank you, Mr. Chair, and thank you, State Attorney Mahoney, for coming and testifying on this bill today. My understanding of the one of the reasons why the State's Attorney's Office and felt this was a necessity was based upon the fact, particularly with those child sex abuse victims, and sometimes it being very difficult for a child to recollect specific dates. Is that correct?
Yes, that's correct.
Okay, would you mind just elaborating a little bit on that? And
Sure. So when this abuse takes place, it's not a happy event that a child has put down in their diary. It's not a field trip. Sometimes because of the chronic nature, so it can happen over and over again, or it can happen for months on end, and then there could be a separation where nothing happens, and then it starts up again another year. The child has no idea. The offender knows why they're picking and choosing the dates and times that they are, but the child does not. And it's sort of a blur after a while, because if they're particularly young, they don't even necessarily understand the act overall. And it's as they get older and they find out what's happened to them that sometimes they first disclose because they are protected. I believe both of the cases that were before the Connecticut Supreme Court were child abuse cases. They were not my cases. But this this proposed legislation is meant to deal with that, to allow us to charge a continuing course of conduct, to allow children to be able to come in and testify about what happened without having to say, and oftentimes it happens in the same location over and over and over again. So it's not like we're going to be able to separate those out and add into different charges. And we certainly don't want to be in a situation where we've got thousands of counts. That really is not a realistic trial strategy.
Thank you. And if I may, Mr. Chair, just another follow up on same point. So my understanding is that the Supreme Court recommended, I don't want to say recommended, but basically said that the legislature should take another look at this. Is that correct in their decision?
That's my understanding as well. I think it's in the Joseph E. decision. I believe it's footnote 20, where the court says that they are not unsympathetic to child victims, and where there is this kind of chronic abuse, but their role is to interpret the statutes, and they feel that the statute as written does not allow them to find the continuing course of conduct, whereas the risk of injury statute does. And they, I believe in that footnote, also cite to, I believe, California and New York as having statutes that have this continuing course of conduct. And whoever drafted this particular bill, in my opinion, did a very nice job, because it's all laid out here.
And thank you. And just final question, if I may, is just in terms of constitutionality. I know there was been some concerns raised with the way we were drafting the bill, and I'm happy that you referenced it because it's a good segue. Obviously, we want to make sure that this is constitutional if it's done. So anything in terms of, I think the Representative Fishbein in his questioning mentioned it, just taking a look at the constitutionality aspect of making it retroactive and how that would impact maybe some crimes that have already been committed that the state may be prosecuting in the future. Do you have any comments or expertise on that?
I would say not, I don't have any expertise on that. There might be people in our appellate division who are better able to answer that, and I could have them follow up with you, and the committee, but particularly the issue is that this was a new interpretation of sexual assault. So I don't know if the issue had never been raised before to the Connecticut Supreme Court, but I believe that there are past convictions on sexual assaults of continuing course of conduct, and this was new the first time that they've done that. So by making it retroactive, we protect the practice that had been there before, and we don't end up with different victims, especially given that we've done a tremendous job allowing victims to come forward at a later time when they are prepared to articulate what happened to them and feel safe. And in order not to punish the victims who were able to come forward earlier before this decision came out, the state's position is the fairest way is to incorporate them all.
Well, I thank you, State Attorney Mahoney. I want to thank the chair for giving me the time to ask questions. I appreciate your testimony and your expertise and your hard work. I do certainly support this proposal. Anything we can do to help prosecute crimes in which children that are sex abuse victims are dealing with that. Anything we could do to help prosecute those crimes, I'm in support of, and certainly helping them as well as the victims as they suffer with trying to bring these cases to trial and potentially testify and bring about events and that obviously they don't want to relive. So I appreciate your hard work and thank you for testifying today.
Thank you.
Representative O'Day.
Thank you, Mr. Chair. And good morning, State's Attorney Mahoney. How are you?
Good morning.
Just real quick to echo the comments of my ranking member, just concerned about the due process aspect of things. Have you talked to the state's public defender's office and get their position on this?
I have not. I did not see that they submitted any testimony in opposition. I was trying to figure out where the opposition could come from. I could see that this could actually inure to the defendant's benefit because it's far better to be convicted of 2 counts of sexual assault than 15 when it comes time for sentencing. I think it also narrows the issues at trial so that you can really focus on what's gone on here. I know oftentimes when there are multiple counts that defense attorneys are worried that the jury just thinks, my God, if you've been charged with that many crimes, you must be guilty of something. So we'll just pick one of these. And that does not work to an accused person's advantage. So from my point of view, I think that this legislation would work for both sides.
Yeah, well, thank you very much for that. And if you hear from them, I've reached out to them as well and let us know. But thank you so much for your work for the state and for your testimony. Thank you, Mr. Chair.
Further questions or comments from the committee? Further questions or comments? Seeing none. Attorney Mahoney, thanks for being with us.
Thank you very much, Chairman. Good day.
Amber Blangus. Amber Blangus with us. Okay, let's try Patricia Weaver. Patricia Weaver. All right. Anne Minuski. Anne Minuski. Michelle Voigt. Michelle Voigt. Karina Martin.
Good morning, distinguished members of the committee. Thank you for having me here today. My name is Karina Martin. I am president and founder of Mothers of Victims Equality, Inc. I am here to support HB bills number 6637 and 6737. You have heard previous testimony in conjunction with HB 6637. I'm here as not just a victim's advocate, but also as a victim myself. Knowing that this will be able to provide participatory ways in which victims are able to face their accuser. I understand in previous comments or questions that there was concerns about it being re-traumatizing, about it being harmful to the victim or rehashing, reliving. There are also, in my opinion, it's a way of gaining back control that has been taken away from a victim. A lot of times, knowing that there is a hearing coming up, it is our choice to be able to attend, but knowing that we have that choice is part of that control. So I would ask that HB 6637 be taken into consideration as being a means of giving back control to us victims. should I testify on 67372 or?
If you want to briefly comment on that, sure.
Okay, briefly commenting on it. I feel that it is also, again, a way of gaining back control for minor children. 6637 states that, to be able to make it a crime to communicate in a harmful manner, more in a sexual capacity, or in a predatory way, that can be harmful to minor children under the age of 18. There is some language in there that I can understand can be a little bit misconstruing or broad in spectrum, but for the most part, I believe that it still does have that ability to be able to give the victims the means of taking back control, of not just being subjected to reliving what they have gone through, but it also opens up to school bullying. There's a lot of cyberbullying going on in schools now. So being able to have a law that can protect our children, I feel is one that is good.
Thank you very much. Senator Kissin.
Thank you very much, Chairman Staffdrum. Thank you so much for your very thoughtful testimony. On the second bill that you testified on, you said the language is a little broad. Do you have any ideas as to how we might narrow it a little bit? But obviously, I think the goals we want to attain I'm in complete agreement with you.
Sure, yes. Narrowing it down to be more specific into the capacities of how the communications would be harmful to said minors. As I had stated, cyberbullying is something that is on the rise in school systems. I work with a charter school in my area. And one of the things that we have noticed, not just within that school, but within surrounding schools, is a lot of cyberbullying going on. So to narrow it to not just be where the communications would be computerized or just through texting, with phone, but to narrow it in the capacity of saying not just photographic, but also in the words of meaning in words as well, not just with photos or just with communications back and forth with that person, but to narrow it in the capacity of making sure that the way in which the predators are seeking to traumatize or harm said minor children, that it's just a little bit more specific.
Okay, I get where you're going, and I think we'll have our work cut out for us in crafting the specific language. And a lot of times it's clearly minors versus minors, right?
Right.
It's the same kind of bullying that took place when I was a kid on a school ground, but we didn't have computers at our disposal. And so now people, and I think that also gives them a little more liberty because they feel like they're hiding behind, you can be up in your attic, in your playroom, saying mean things to another kid that's across the other side of town. And it can be really devastating because so many of our young adults and children gather their self-esteem in ways that we never even conceived when we were young.
Right.
And in particular, one of the concerns that I have is young girls and, the spike in suicides because they are attacked online and they get devastated by even someone photoshopping their picture or saying things about their appearance.
Right.
And so it's tough to get our arms around, but it's something that we have to send a strong signal that it's unacceptable.
It's
So
not
thank you for your work out in the community.
Oh, no, thank you for
Thank you,
acknowledging.
Chairman Staffstrom.
Further questions or comments, Representative Howard?
Thank you, Mr. Chairman. Good morning, Ms. Martin. Thank you for being here with us. You testified first on 6637, and I heard you say concerns over re-traumatizing victims, and I heard you use the word control.
Mhm.
Can you just for my benefit and the benefit of my colleagues and those listening, talk about what it means to a victim of a crime to see the perpetrator of that crime taken fully through the justice system and be convicted and serve out their sentence, be it probation in this case or if they're on parole, et cetera. Can you just talk about the impact that that has on victims when that perpetrator is convicted and sees their sentence?
It's empowering. It does not mitigate the crime that has been committed against that individual or family members in my case. But it is empowering to be able to know that you have the judicial process working in your behalf, on your behalf. Sometimes it might take a little longer, I can attest to that, but it does eventually have an outcome. As far as with probation and violation of probation, that's still an extension of that. So I know that Attorney Pierre, she had said that when she gave her testimony, she had said that, it is up to the discretionary discretions of the judge to be able to surmise what should be added part of the testimonial portion when it comes to violation of probation, if that has validity to that case at hand. But just knowing that this person is still being processed through the judicial system and you having an impact of that process is empowering. That is taking back that control. So I hope I answered that for you.
I
Representative
think you
Bowers.
did a wonderful job, and I'm grateful that you're here.
Mhm.
We have a criminal justice system that by nature of that exact system re-victimizes victims over and over again. Unfortunately, it's necessary. It's a necessary part of our system in a free society to make sure we don't convict people who are innocent of crimes. But oftentimes in this legislature, we don't get too many victims that are willing to come forward and testify before us on policy for those exact reasons. They've been through enough. So anytime someone like yourself who's been a victim of crime, who has the courage to sit here and make your voice heard, I applaud you for that. And I'm very grateful for you being here and sharing your story with us. Thank you, Mr. Chairman.
Thank you so much for that.
Representative Fishman.
Thank you, Mr. Chairman. I too want to thank you for coming here today, appearing in person. Your advocacy is very important. And, I have no questions for you. I just wanted to thank you once again for the exchange and for you giving us your perspective. So thank you.
Thank you so much, sir. Thank you for this.
Further questions or comments? If not, I want to thank you as well for being here. Appreciate your time and testimony this morning.
Thank you all. Thank you for having me.
Evelise Correa. Evelise Correa. All right. Amber Flangus. Patricia Weaver. Ann Minuski. Michelle Voigt. Evelise Correa. If not, that concludes our public hearing. Declare this public hearing closed. Thank you all for being with us. This might be the shortest Judiciary Committee public hearing in modern history. We are off on Friday. We will be back on Monday, in which I anticipate a slightly longer public hearing than today, but we